So, why does Christian plead guilty on July 17, 2019 to Class 1 misdemeanor cruelty to animals when he maintains Storm's injuries were the result of an accident, especially when the case against him contains so many inconsistencies and discrepancies?
Well, mostly because he was facing 6 to 18 months in county jail and or up to a $500 to $5,000 fine if convicted. Uncertainty about the criminal justice process weighed heavy on Christian. So did the possibility of going to jail.
Christian assumed the worst possible outcome was going to happen. His anxiety was so severe, he reported experiencing suicidal thoughts at a level Dr. Apgar, the therapist who conducted his animal cruelty evaluation, said was typical of individuals placed on suicide precautions.
Christian wanted a way out.
You're listening to Vulnerable Creatures. I'm Matthew Schnipper.
And I'm Lauren Hugg. This is episode 5. Make It Stop.
What we watched him go through, the anxiety, the fear, doesn't matter, like, because of the way he thinks, there's just nothing we could say to tell him that would give him the patience that he really needed. And he kept thinking it was just going to be over, and I think that was just because of this emotional and the massive anxiety. He's like, please let this be the last one. I can't keep doing this because I can't sleep and I can't eat and I'm freaking out. And that it was that sort of feeling that he had. And we're watching him go through it, and he's like, it has to be done. What do I do to make it stop? That's all he wanted, is make it stop.
That's Christian's father, Mark, a man who believes his son is innocent and believed a trial would prove it. But Mark also saw the toll the legal process was taking on Christian. So did Christian's mother, Shannon.
So for Christian, one of the main things is just he wants to know what's going to happen, right? He doesn't like uncertainty. He doesn't like the unknown. He wants to know. So with the plea deal, he knew exactly what would happen. Okay, I'll have to do community service. I'll have to do X number of hours of therapy, I'll have to pay this fine, and then it's done. And I know the outcome.
When I first started practicing criminal defense, the misdemeanor process was confusing to me. I knew the law and how to try a case, but all the things that happen before trial or in lieu of trial, the forms and appearances and procedures, were mostly new to me. If the process intimidates someone with a law degree, how much more overwhelming must it be for a person with zero legal education? There are lots of different stages, and not all of them apply in every case. Cases get reset over and over again, depending on whatever else is going on with the prosecutors, defense attorneys, or the court. Defendants have no way of knowing when their case will finally be over.
Even Dr. Apgar noted how traumatic the case was for Christian. He reported Christian's feelings of helplessness, hostility and bitterness, failures in close relationships, excessive stress, unhappiness, and suspiciousness. He felt betrayed by Andrea leaving him after 4 years while in the midst of planning their wedding. And there was that fear of going to jail.
Uncertainty can be especially difficult for autistic individuals. Clinical psychologist Dr. Kate Colon, who we met in the last episode, says,
I think the first thing that comes to mind is just cognitive flexibility, right? So kids on the spectrum, they tend to be more rigid. They like things in a certain way. They like to know what to expect.
Leanne Paskevich, executive director for the Autism Society of Colorado, told us,
uncertainty for people on the spectrum is so overwhelming, and it goes back to when they're 5. Like, what are we going to do tomorrow? What are we going to do tomorrow? I don't know. What do you want to do tomorrow? I don't know, but we need to have a plan, and you have to tell me what we're going to do tomorrow because I need that certainty. And so I could see why people plea who are on the spectrum, and people not on the spectrum too, because everyone likes to know what's going on. Pleading is the lesser of two evils because then it ends.
But it wasn't just the uncertainty of the process Christian was anxious about. Here's his mom, Shannon, again.
You know, one of the things we were concerned about and Christian was concerned about was a jury, because you just never know how they're going to take the information, right? Christian lied to his girlfriend. People automatically will make assumptions. People would have this bent opinion about him from the start. So there was just a concern, if we go to trial and he was found guilty, he was very scared of those ramifications and the unknown, the uncertainty about it.
When I practiced criminal law, I used to start voir dire, jury selection questioning, with how many of you walked in here today, looked at my client, and thought, I wonder what he did? Roughly half to 2/3 of the hands in the jury pool would go up. Presumption of innocence is supposedly a foundational concept of the American criminal justice system, but our attitudes and our behavior contradict that presumption. Once someone's been charged with a crime, people tend to assume the accused is guilty. Why would law enforcement go to all the trouble to investigate and arrest this person if he didn't do it? Why would the DA's office charge him if they weren't really sure he did it?
It was reasonable for Christian to be concerned about how a jury would perceive not only the evidence, including photos of a bloodied kitten, that could easily stir emotion, but also how they would perceive him as an autistic individual. Autism forensics expert Dr. Laurie Sperry says,
I do advise attorneys to educate the jury about that. And here's the reason: how you present to a jury your affect is going to impact your sentencing. And so people with autism have bizarre or absent demonstrations of remorse. And so I call it the damned if you do and damned if you don't phenomenon. That is something that the jury needs to know, that this person may not, demonstrate remorse in the way you understand it. They may laugh because they're nervous. They may have a neutral affect, and you're interpreting that as, a cold-hearted psychopath. And so it's important that juries are able to view the behavior of the defendant through the lens of autism while they're in court. And I don't recommend putting the defendant on the witness stand unless it is so obvious that they have autism that would work in their favor. Because if there's somebody with language skills and then there's the circumlocution and the obfuscation that happens when you're on the witness stand, even in terms of like multi-layered questions, I have not seen it work to the benefit of the defendant.
Imagine for a moment what going to trial is like for any defendant. An unfamiliar setting filled with unfamiliar rituals and legalese you don't speak, a judge looking down on you, a bailiff with a gun standing to the side, jurors watching your every move, prosecutors hurling accusations, witnesses saying terrible things about you, all while you are forced to sit there, silently and still, avoiding any behaviors that might make jurors think you're guilty. Now imagine you're autistic, and you're already used to having your natural behaviors judged. How much more stressful and anxiety-inducing would a trial be?
Merely being charged with a crime forces defendants into making choices about trial versus plea. The risk of receiving a harsher penalty because of maintaining their innocence and going to trial is real.
Defendants who take their case to trial and lose receive longer sentences than even Congress or the prosecutor might think appropriate, because the longer sentences exist on the books largely for bargaining purposes, says NYU law professor Rachel E. Barkow in a Stanford Law Review article cited by the Supreme Court in Missouri v. Frye. This often means people who accept a plea bargain receive shorter sentences than those who go to trial.
Add that to a never-ending legal process where defendants have to show up to court over and over again, taking off from work, finding transportation and childcare, or they're enduring the trauma of jail because of their inability to post bail. A lot of factors influence a defendant's decision to take a plea.
As the Supreme Court pointed out in Loeffler v. Cooper, our criminal justice system is for the most part a system of pleas, not a system of trials. 97% of federal convictions and 94% of state convictions are the result of guilty pleas. There's no way every single one of those cases would result in a guilty verdict if the case was taken to trial and the prosecution was required to prove guilt beyond a reasonable doubt. Plea deals alleviate the requirement that the prosecution meet their burden of proving each and every element of the charge to obtain a conviction. But when a defendant enters a plea, the assumption by prosecutors, law enforcement, judges, and much of the general public is that the charges were true, and the evidence in support of those charges was strong. Really, all it proves is that the prosecutor made the defendant an offer they'd be a fool to refuse.
Even Corporal Cheney acknowledges the game with plea deals.
I mean, I can't tell you how many times my cases have been, there's been cases with each and every officer that have either been dismissed or plea bargained. I mean, obviously the system, they plea bargain cases like all the time, which I'm like, hey, I'm fine with that. I'll never be the person to call you up and be like, hey, why did you do this or that with my case? Like I said, I didn't even know what happened with the case.
The constitutional right to trial is enshrined in the Sixth Amendment and is often cited as the gold standard. But in practice, it's an inquisitorial, confession-based justice system, says Rebecca Schaefer, legal director of Fair Trials, a global criminal justice watchdog. Those 97% of federal cases that are resolved with a guilty plea make the U.S. the world leader in the use of plea bargaining. That percentage has remained stable for the past 2 decades. The watchdog says plea bargains corrode the fairness of the justice system when guilty pleas can persuade innocent people to admit crimes they did not commit. And pleas reduce oversight and transparency of arrest, charging, evidence collection, and sentencing practices.
That happened in Christian's case. The fact that he pled made animal law enforcement and the DA's office less interested in examining potential errors in their work.
University of Chicago law professor Albert Alschuler, a vocal critic of plea bargaining, calls pleas extraordinarily coercive, saying that people would certainly regard it as coercive if the prosecutor offered a lesser sentence in exchange for, say, the defendant waiving their right to counsel or their right to challenge the qualification of jurors. When I was studying for my Master of Laws in London, I was shocked when my international classmates insisted that the U.S. wasn't as committed to trial by jury as I'd been led to believe by our national myths and by the rhapsodizing about that right in law school. But when I actually started to practice criminal defense, it was abundantly clear that trial is a rarity and pleas dominate. In Christian's case, the prosecutor presents a pretty attractive alternative to trial. Plead guilty to a Class 1 misdemeanor for cruelty to animals charge, receive a 12-month deferred sentence on that charge, and the other charge will be immediately dropped. If over the course of 12 months, Christian completes an animal cruelty evaluation and related therapy sessions, 20 hours of community service, and pay court costs and restitution,
meaning pay Andrea back for Storm's medical bills in this case,
and he doesn't get into any other legal trouble during that time, all charges will be dismissed. Christian will then have the right to seal his record.
The judge, in explaining Christian's rights, says,
by pleading guilty, you're getting the benefit of a deferred sentence. If you go to trial and the jury returns a verdict of guilty, then there's no deferred sentence. It's an actual conviction.
This is the pragmatic reality people face when charged with a crime they insist they didn't commit. Assert their innocence and risk conviction and potentially more severe penalties, or plead guilty for guaranteed dismissals and or lighter penalties.
As Christian's defense attorney Bryson Perkins summarized in an email to Christian's father Mark in June of 2019, and these are his words, not his voice.
The advantage of the offer is that it eliminates the risk of trial. Control of the outcome lies with Christian. If everything gets completed, the plea is withdrawn at the end, and the case is dismissed. With a trial, it's in the hands of the jury and how they perceive the evidence presented. I still feel there is doubt, and a not guilty verdict is definitely possible, but there is also risk.
As we heard from Christian's mother, Shannon, accepting the plea would mean Christian would know exactly what would happen. And control and certainty was important to him.
Makes sense, but quick digression. Why was Christian's lawyer communicating with Christian's dad instead of with Christian, his actual client, directly?
Well, as Mark Mahoney, an attorney with extensive experience defending autistic individuals in criminal proceedings, told us via email, family members can be important advocates. Parents of defendants on the spectrum can play an incredibly important role in defending their loved ones throughout the complex legal process. Parents need to tell attorneys the story of their child, their developmental history, and their step-by-step struggles.
No doubt, Mark has been a big advocate for his son throughout this ordeal.
But back to Perkins. The attorney's assessment of risk at trial included the fact that the DA's office said they approved the request for paying for out-of-state travel to bring Andrea in from the East Coast to testify. Perkins found that highly unusual. He told Mark he'd never seen that done before on this type of case. So we asked the DA's office how often they fly witnesses in for misdemeanor cases.
Chief Deputy District Attorney at the time, Jeff Lindsay, told us,
so it really depends on the case and depends on the seriousness of the case. It happens most often in felony cases, just generally speaking, and not as often in misdemeanor cases, and it's obvious why, because misdemeanor cases aren't as serious as felony cases.
We spoke with another former prosecutor and a defense attorney unrelated to this case, who confirmed that the DA's office almost never flies in witnesses for misdemeanor trials, but that the office might for an animal cruelty case. We were told once again how seriously the DA's office treats those cases. So seriously, in fact, that during our reporting for this story, in early 2021, recently elected DA Michael Allen formed a new, dedicated animal cruelty unit composed of more than a half dozen prosecutors, citing how their district's office fields more calls from the public on animal cruelty cases than any other type, aside from high-profile murder trials. Of note, he cited evidence of the link we described in earlier episodes.
And so it's just a way to hopefully curtail further criminal involvement by addressing it earlier in the process if we possibly can, and getting those folks the treatment they need so they don't reoffend, but also protecting our furry friends and victims of domestic violence.
Remember, Corporal Cheney's supervisor Lindsay Vigna told us this case was felony level. Corporal Cheney thought it was serious enough to advise Andrea to leave a 4-year relationship and seek a protective order. Flying a witness in to testify says the DA's office saw this as a serious case as well, despite knowing Christian's version of events, that Storm fell off the balcony.
There's no sensitivity or understanding about how autism impacted Christian's reactions. Deputy DA Lindsay told us,
that guilty knowledge, I think, is pretty consciousness of guilt type of behavior by the defendant is really, to me, what's most telling. The way he kind of blew off the girlfriend, and that just to me is like, yeah, this guy should have known better. And then his explanation was pretty sketchy, and then the way he responded to her going to the hospital was also, I think, indicative of consciousness of guilt. Something happened to that cat while that cat was in the defendant's care. He didn't get treatment for the cat even after, even if you believed his story, which is pretty sketchy.
It was tough to hear Lindsay say that Christian should have known better, because that's the expectation that he should have acted in a neurotypical way, the way an average person would have acted. Well, Christian's not neurotypical. He has autism. That information was available to the DA's office.
During our interview, Deputy DA Lindsay transparently said that he didn't know a lot about autism, but he related a story about another case he worked where the defendant had a condition that hindered him from being able to read body language and facial expressions. Lindsay said the DA's office went to greater lengths to speak with the boy's family, create an understanding of the issue, and essentially make appropriate accommodations. He said,
just human nature to be able to read body language, to understand, this person's frowning at me, he's mad at me.
But the more we all learn about neurodiversity, the more we're coming to realize that reading body language isn't entirely innate. It's also learned. And we don't learn to interpret body language exactly the same way. It's just generally assumed that we do.
At one point, Lindsay asked us if we knew if autistic people are more prone to committing animal abuse. Well, we aren't the experts either. So we'll let Temple Grandin effectively field that one with something she told us.
There are people that like to torture animals, and let me tell you, autism has nothing to do with it. A lot of autistic individuals love animals. They have service dogs, they ride horses. There's so many autistic people where animals are their life. And they really love animals because they're awkward with people and they treat their animals really well.
As long as this is hanging over him, it is damaging to him, emotionally.
That's Christian's mom, Shannon, explaining Christian's state of mind. So despite maintaining his innocence, on July 17, 2019, Christian pleads guilty to failure to seek vet care. A lot of prosecutors and judges require defendants to admit their guilt as part of accepting a plea bargain, because they want defendants to take responsibility for their actions in order to earn less severe penalties. They won't allow a defendant to enter a plea while maintaining innocence, but that means there have to be mechanisms for innocent defendants to take advantage of plea bargains without saying they're guilty. A no-contest plea is one way. A defendant doesn't admit guilt or innocence, but acknowledges the prosecution has enough evidence to possibly convict. In North Carolina v. Alford, a 1970 case, the U.S. Supreme Court acknowledged a different kind of plea, one where a defendant pleads guilty while asserting innocence in order to avoid the penalties that would come with conviction at trial. In that case, a man faced the death penalty if he pled not guilty to first-degree murder and was convicted after contesting the charge. He didn't want to plead guilty, though. So instead, he pled guilty to second-degree murder and said he was doing so to avoid a death sentence were he to be convicted of first-degree murder after going to trial. "I just pleaded guilty because they said if I didn't, they would gas me for it," the defendant wrote in one of his appeals. Law professor Albert Alschuler told Frontline, "I think it's hard to imagine a clearer denial of due process than sending someone to prison who hasn't been tried and who hasn't admitted his guilt. But the Supreme Court of the United States says that's okay." Nevertheless, Alschuler is reluctantly in favor of Alford pleas in a system where rampant plea bargaining has deprived guilty pleas of their meaning. It allows a defendant to avoid a more severe punishment without having to confess to something they didn't do. In my experience, an Alford plea is a more honest expression of what innocent defendants are doing when they plead guilty to avoid the risk of trial. Many accept the legal fiction that they have to say they did something wrong, even when they know they're innocent, in order to take advantage of the plea deal. But some, like Christian, can't bring themselves to lie about their guilt, even when the plea deal is in their best interests.
An Alford plea would allow Christian the cognitive flexibility he needs to accommodate his own sense of justice, while still cooperating with what the prosecution deems appropriate based on their interpretation of events. In the words of Christian's mother, Shannon,
He's black and white. He's very much like a black and white thinker. Something either is or it isn't.
And as Christian's attorney Bryson Perkins says during a plea hearing,
"I've talked to my client and his father at length about this, Your Honor, and I simply believe that he cannot bring himself to say he did something wrong. But he wants to take advantage of a deferred sentence."
This prosecutor doesn't like Alford pleas, though. He wants Christian to admit he did something wrong in exchange for the plea deal.
Legally, there's really no distinction, and it's still a guilty plea,
says the court at Christian's plea hearing. So an Alford plea would have made no legal difference at all to the prosecutor. For Christian, though, being able to maintain his innocence while accepting the plea would have made a tremendous difference in his mental health and in his ability to move beyond an incident that was traumatic for him. But the prosecutor was unwilling to provide that minor accommodation.
Were they afraid of having a legal precedent set? That word would get out that their office was now open for business on Alford pleas? If the prosecutor had the proper training to better understand autism, perhaps then they would have allowed an Alford plea in this case.
Attorney Mark Mahoney, the one who specializes in defending autistic individuals, argues that the system isn't designed for and tends to greatly fail persons with autism due to a lack of understanding, as well as rigid enforcement of policies. He says it's very hard to get prosecutors to understand what they're doing and how it destroys the lives of innocent people.
Autism forensics expert Dr. Laurie Sperry says the outcome in a criminal case involving an autistic defendant
It really does come down to does the judge, does the prosecutor, does the defense attorney know someone with autism? Do they have any familiarity with it? Do they have an appreciation for how this impacted what happened or the person's response after they came in contact with the system?
Sue Thomas, co-founder of Autism Society Boulder County and the mother of an adult with autism, has done trainings for law enforcement agencies in the past. She advises parents,
if your kid gets into trouble, you need to find someone in the police that understands autism. You can't just expect these people or a judge to know, what's going on.
Because a better understanding of autism makes such a difference in outcomes, a just system can't leave autistic defendants subject to the chance that they end up with legal professionals who get it. We need to educate prosecutors and judges, argues Attorney Mahoney, and defense lawyers too, because they don't usually understand how autism plays into defending criminal cases. He says it takes a lot of work for defense attorneys to understand autism, and lawyers typically don't have enough time in their schedule to learn all they need to in order to resolve these cases. So he says that they need help from professionals, researchers, and clinicians to teach them, so they, in turn, can teach prosecutors.
I completely agree with him. As a parent, I'm constantly learning about autism. And until researching this story, I never thought about how it impacts a defendant navigating the criminal justice system. I searched for resources aimed at advising defense attorneys how to best represent an autistic client, and they're hard to find. I think representing autistic individuals should be the topic of law school classes and continuing legal education courses. Thankfully, there are experts like Dr. Sperry working to provide information on autism to professionals within the legal system.
I have had some judges that really have been so appreciative. And then I have defense attorneys that I've worked with who have made it their mission to say, I want to learn as much about this as possible. And so then they really appreciate, like, when we can go through a case and figure out, like, what are the characteristics of autism that were implicated in this, and what are mitigating factors that should be considered. And as far as prosecutors go, that's really a mixed bag. There have been, some prosecutors who have publicly said, well, isn't that convenient? Or, this seems to be the diagnosis du jour to get you out of XYZ charge. So, in particular, there was a prosecutor who said it in the media, and he called it the defense du jour.
She says she had an argument with the prosecutor once about mens rea, the mental intent to commit a crime, versus actus reus, the physical act of the crime.
He said, so you're telling me that they can't be held responsible for their actions, and if that's true, then they shouldn't be allowed to walk amongst us.
That attitude is similar to one Mahoney says he's encountered with prosecutors. The fact that a person with autism seems odd in some cases escalates prosecutors' sense of danger, he says. They're afraid of opening the floodgates, that everyone will say that they have Asperger's, and prosecutors won't be able to figure out how to differentiate between those who really have severe social deficits and others who are simply looking for an excuse to avoid prosecution.
But when a prosecutor is unwilling to make an accommodation for an autistic person, which has no legal implications whatsoever, like allowing Christian to enter an Alford plea, we have a big problem in our society.
Our legal system could still be effective at prosecuting crimes while showing a little empathy. When we spoke with the DA's office that prosecuted Christian's case, they expressed an interest in autism training. Last we checked in, it hadn't happened. But it's not just lawyers and judges who need training in autism. Law enforcement needs training too.
An academic study in 2017, published by Philadelphia's A.J. Drexel Autism Institute, estimated that by age 21, 1 in 5 youth with autism have been stopped and questioned by law enforcement officials, and many end up getting arrested. Dr. Sperry says,
police officers, understandably, are trained in rapid response decision-making, and so they expect people to behave in a certain way when they approach them. Police need some additional training around, like, hey, and when you approach this person with autism, they're not going to respond in a way, so give them distance, give them time to respond, don't yell, those sorts of things. And a registry so that police officers knew when they're going into the situation that that's what they're going into, and they have time to think back on their training.
Some progress is being made on requiring first responder training. In 2021, Colorado passed a bill creating a 12-person commission that includes persons with a disability, parents, and representatives from advocacy organizations. They were tasked with studying the current training for peace officers on interactions with persons with disabilities and recommending a curriculum.
While training about autism can go a long way in making the criminal justice system more humane, that's setting the bar pretty low. There's so much more we could do. Here's Dr. Sperry again.
We have an autism-friendly Santa. You know what I mean? Like, malls have sensory-friendly Santa. And we can't have an autism-friendly court? Why don't we have something like that?
That sounds sensible. I mean, across the U.S., we have devoted teen courts, drug courts, mental health courts, specialized veterans courts, even homeless courts. Would autism court really be a stretch?
Or another of Sperry's suggestions, to develop and require autism-friendly court practices, like submitting questions in writing and allowing the person time to read it, think about it, and respond to it.
They're layered questions, and they are not in the native language, so to speak, of the person with autism. I'm really articulate, and then I go into court, and my heart just about hammers out of my chest, and I have to do a lot of self-calming before I go in and think about the question for a long time. And I'm not somebody with autism, so we know that the ability to access your communication drops immediately and precipitously in times of stress for a person with autism. That has to be taken into account.
Or what about an autism advocate for every autistic defendant? Here's Dr. Sperry again talking about the UK approach.
They are really doing some groundbreaking work that I think the U.S. system could learn a lot from. They have laws in place around if you as an officer or you as a barrister think that the person you're interviewing has autism and they have a checklist, you have to stop questioning and get in what's called a responsible adult. We're getting an advocate in there. We don't have that, and then people with autism self-incriminate all the time.
Leanne Paskvilich of the Autism Society of Colorado says,
I think a person on the spectrum should expect to be able to function in the world like everyone else. If you need help with your vision, you get glasses. If you need help with hearing, you get a hearing aid. If you need help with social communication and understanding perspective and perspective taking, maybe you get some coaching on that. Maybe you have someone available that you can talk through situations with. And that might be your parent, that might be a therapist, that might be an educator. It's on all of us to build a world where everyone is accepted.
Autism researchers in the UK are working on exactly that, translating research findings into policies that provide every autistic person with a lifelong support worker to whom they can turn to help them navigate the world. An advocate or support worker would likely have made a big difference in the case of Matthew Rushin, an autistic 21-year-old who pled guilty in early 2019 to 2 charges of malicious wounding and 1 charge of hit and run. He was given a 50-year prison sentence. A police interrogation video shows him telling the police that he didn't mean to hurt anyone and insisting that he tried to stop the car. If the behavior was accidental instead of intentional, it wouldn't merit criminal charges so severe. His mother said Matthew accepted a plea deal because he believed it would allow him to come home.
We're kind of at the beginning of a movement. Neurodiversity is kind of the next human rights movement,
says Paskvilich. And that's good news for all of us. As we're learning in all areas of society, changes that accommodate people struggling with some aspect of an accepted norm often benefit everyone.
When it comes to looking out for animal welfare specifically, former Institute for Human-Animal Connection Director Phil Tedeschi says,
if we really want prevention, then we want healthier communities and healthier people, not just punitive strategies and calling people out and shaming them for, being bad. If we're really trying to be interested in the broad sense of the word in animal well-being, we should be interested in these humane community principles around better governance and more highly educated personnel and leadership that establishes resources, and that we really understand that that's likely to create the most effective outcome. As we criminalize various kinds of animal protection issues, it places a lot of pressure and over-policing on communities that lack resources, often don't have good supports, legal supports, and things like that. The messaging that's come out of the animal welfare movement as a feature of this concept of the link is kind of a hard on crime message, right? A message that, one of the ways we should be responding to animal cruelty is by getting harsher and potentially even being more interested in carceral approaches to responding to these issues. And I think that's really an unfortunate message, in part because we have no reason to believe those individuals would be improved by being incarcerated. And the reason we know that is by studying the origins of animal cruelty. And almost always, they're falling into categories that include things like poverty, mental health issues, traumagenic issues, and in some handful of cases, criminogenic issues. And so lumping them all into this category where we somehow see that animal cruelty as this kind of direct path to antisocial personalities or mass murder or serial killing or what have you, just as a form of ramping up the rhetoric that does not actually reflect what really is happening in these cases.
Incarceration is an awful penalty for anyone, but it's especially awful for autistic individuals, making the risk of jail time even more frightening for them. Here's forensic autism expert Dr. Sperry again.
Just when you think about what jail or prison would be like for a person with autism from a sensory perspective, that's heartbreaking, and then what are we doing in there? Are we just holding people and then letting them out? Or are we really providing autism-specific support and training?
Sperry wonders why we don't have sensory-friendly portions of jails.
I tell clinicians when I present to them, the worst day of your career will be seeing somebody with autism in jail or prison. Autism is and always has been defined by social impairments, right? And so if I got arrested and went to jail or prison tomorrow, I would make friends with the biggest, most tatted up woman there, because I would know that I would need protection and I would need affiliation. And people with autism are unaffiliated prisoners. And so they are very vulnerable to exploitation in prison, more vulnerable than the neurotypical person. One might argue, though I've been told that that's ridiculous when I say it, but one might argue it's a violation of the Eighth Amendment.
The Eighth Amendment. Cruel and unusual punishment. That sounds about right. In fact, I'd take it one step further and argue the entire criminal process could be considered cruel and unusual punishment for an autistic person, because it's riddled with uncertainty, unfamiliar situations, and environments with limited accommodations for sensory overload.
Attorney Mahoney says that in prison, people with autism suffer all the problems of a new, complex social system. It's impossible for them to try to figure it out. They're victimized, especially for tattling on other inmates who violate rules, something most people with autism hold very dear, as they provide needed structure. Horrifically, he says, many people on the spectrum will end up in solitary confinement for most of their sentence, something many advocates equate to psychological torture.
In 2018, Laurie Love, an autistic UK student accused of hacking into the US Federal Reserve and the Missile Defense Agency, won his request to not be extradited to the US for trial because the UK court agreed with him that conditions in US jails are highly conducive to suicide, especially for a person who is hypersensitive to sounds, lights, unfamiliar people, and unexpected change.
Attorney Mahoney argues individuals with severe social learning deficits shouldn't even be prosecuted if they didn't know they were doing something wrong when the offense was committed. Prosecutors don't know enough about the tendency of people on the spectrum to follow rules, he says, backing up something we heard from Dr. Sperry.
What we know about folks with autism is that when you teach them the rules, they'll likely follow the rules.
Says Temple Grandin.
First of all, one of the things you need to tell them is what the rules are, and somebody needs to just show them. And that's the way you have to put it to them, just straight. These are the rules. Now, I've divided the rules into levels of severity. I have a thing called illegal but not bad. But an illegal but not bad, when I was in high school, riding my horse without a staff member being present. I basically had a rule system, and it's in my book, The Unwritten Social Rules. I have really bad things like murder. Then you have the courtesy rules to help people get along. Then you have illegal but not bad. And then you have the sins of the system. The sins of the system get you in so much trouble, man, you just stay the hell away from them.
Without explicitly being taught a specific rule, an autistic individual might do something that seems reasonable based on other observations, but that happens to be against the rules they've never been taught. When we shared with Mahoney that Christian's case involves an accusation of animal cruelty, he responded that somebody with autism might do things to animals that others think is cruel, but the person with autism sees people eating hamburgers, paying exterminators to get rid of vermin, and putting thousands of stray animals to sleep at the animal shelter, and wonders why people are so upset.
Tedeschi also pointed out the inconsistencies in the way we treat and protect animals.
Our relationship with our animals are complicated because on one level we have a society that's super passionate about their companion animals to the point where, their level of reactivity and emotionality on these issues makes it hard to promote an accurate discussion about them. And then there's other areas where we're entirely kind of shut down and callous and having no conversations. Things like our treatment of farmed animals or cruelty that's kind of socially legalized, like the killing and culling of geese, for example, in state parks. We have a very curious kind of ways of talking about and reacting in some places and not in others, especially with animal cruelty, because we have, like I said, we have this emotionality about it, but we also have a lot of carelessness rights and ethical issues, even in pet keeping, where if somebody leaves who says they love their animal, will leave their animal locked in their house for 9 hours in a day. Those are forms of cruelty too, and yet in that affluent neighborhood, that's not where they're going to get a citation for that. That will never get reported.
The DA's office, Dr. Walker, and Corporal Cheney all thought Christian should have known to get Storm to the vet right away. But given that an expert in human-animal connection thinks keeping an animal locked in a house all day is a common form of cruelty that never gets prosecuted, is it really that obvious what should be considered cruelty in cases where a human has no intent to inflict harm?
Christian didn't know what to do when Storm was injured, but he does now. He told Dr. Apgar that in hindsight, he should have immediately taken the cat to the vet and not have waited for Andrea to come home. These days, he says anytime his cats Charlie and Angel show any signs of medical issues, he immediately takes them to the vet, no matter the cost. Now, it may sound like Christian's story ends here, with him pleading guilty and learning about how to care for his cats, but actually it doesn't.
Despite his need to make it stop, a few months after pleading guilty, while he's still completing the terms of his deferred sentence, his family hires a new attorney, one who works in post-conviction relief. The attorney and a private investigator embark on reinvestigating the case to find the evidence they need to undo the plea.
Why? Because Christian insists on his innocence, something an Alford plea would have allowed him to maintain, and his family wants to clear his name. The danger there, if the plea is successfully undone, it once again raises the risk of conviction that haunted Christian before. In the next episode, the Breuer family seeks legal justice. We learn how ineffective assistance of counsel claims have the potential to vindicate defendants. We hear a call for institutional empathy across the complex legal system, and we examine the true cost of fighting for innocence.
You are just cutting him off at the knees. And you don't care what he's lost. You don't care what he could lose. You don't care at all. None of you care. Like, you just want to push the paperwork through.
Before you advise your client to plead guilty, you have to know the case. And that's what bothers me about the case right at front.
But it brings the standard of practice down for people who are on the spectrum, and that's not acceptable.
The burden is placed on families. The burden is not on the system. The system just does what it's designed to do.
Vulnerable Creatures is written, directed, and hosted by Lauren Hugg and Matthew Schnipper, and produced by Vehement Visuals in Colorado Springs. Voice actors in this episode are Talbert Blanchard and Kirk Woundy. Original music by Michael Johnson and Dave Pastor. Logo design by Ryan Hannigan. Special thanks to our Patreon supporters.
Every time